Okay, hello and welcome everyone. My name is Samantha Prosser and I'm a Senior Associate here at BDBF. I'm joined today by my colleague James Hockley, who's an associate in our team. Now the Christmas party season is just around the corner and no doubt we're all looking forward to letting our hair down, especially after years of COVID restrictions. And they can be a lot of fun, but they do have the potential to generate some rather difficult HR issues. Now, hopefully our talk today won't fill you with too much doom and gloom. And the good news is there are lots of things you can do in advance to avoid any HR hangovers. Before we start our talk, there's a couple of housekeeping points first. So we're going to speak for about 45 minutes today. And after that, there will be some optional time for questions and answers. And today's session will be recorded, although the Q&A part won't be. We'll circulate a recording of the session together with a copy of the slides, as well as our top tips for avoiding the HR hangover, which will round up all the practical tips we will mention today. We're presenting in webinar format today, which means that the best way to ask any questions is to type them into the Q&A box, which you'll find at the bottom of your screen, and you can ask questions anonymously if you prefer. So I'll hand over now to James.
Good afternoon, everyone. So let's start by thinking about what you can do to make the party both inclusive and safe. The Christmas party is a great way to reward staff for their hard work and to build team spirit. Therefore, it's important to make sure that no one feels excluded from the event. Start by making sure that no one is missed from the guest list. Don't forget staff who are on long-term sick leave or maternity leave. In a recent tribunal case, a woman on maternity leave said her employer discriminated against her when it forgot to invite her to the firm's Christmas drinks. Even though it was a relatively last-minute event and informal, where staff were invited by word of mouth, the tribunal said that she was overlooked because she was on maternity leave, and this was an act of maternity discrimination. An exception to this rule, of course, might be somebody who's suspended from work, where it may be legitimate to exclude them from a work-related social event. But this will depend on the circumstances and the terms of their suspension. Staff should also know that it's not compulsory for them to attend. There are many valid reasons why people can't or don't want to attend the party, and you should make it clear that those who choose not to attend will not suffer any disadvantage. So what are some specific areas to think about when it comes to making the party inclusive? Well, first, there's the name of the party. For some people, the fact that the party is called a Christmas party could make them feel excluded. The UK is made up of people of many different faiths and others who have no faith. And with that in mind, you could replace Christmas with festive or winter party. Second, the day and the date of the party. Now, whilst it might not be possible to find a date where everyone who wants to attend the party is able to, there are steps you can take to ensure that whole groups of people are not excluded. You should avoid choosing a date that clashes with a day of religious significance. For example, if you have Jewish employees who observe the Sabbath, then holding the party on a Friday evening would mean that they could not attend. Third, the venue. Don't forget that the physical features of a venue can make it more difficult for people with certain disabilities to attend. For example, you may need the party space to be wheelchair accessible. Things like lighting and acoustics may also be relevant. If you opt for a single space without breakout areas, then loud music will make it more difficult for those with hearing impairments or conditions such as autism to participate in conversations. Fourth, food. Many venues are now used to catering to a wide range of dietary requirements. For example, vegan, gluten-free, halal, and so on. And so it shouldn't be too difficult to ensure that everyone is catered for. But ask staff what their requirements are before selecting a venue to make sure that you know that your chosen venue can deliver. And then fifth, alcohol. Remember that there are many reasons why some people don't drink alcohol, including pregnancy and breastfeeding, or religious, cultural, and health-related reasons. You should ensure that there are high-quality, non-alcoholic drinks available, and that the party is not geared solely around drinking. Now, not only is this important from an inclusion point of view, but too much alcohol is often the root of other problems, as we'll see shortly. So with a bit of forward planning, you can make sure that everyone feels involved. Now thinking about if the party is going to be safe. As you know, the range of legal obligations placed on you as employers concerning health and safety is extensive. Importantly, you are responsible for ensuring the health and safety of staff so far as reasonably practicable. You must also assess and review the risks faced by staff, and where risks are identified, you must take steps to control those risks, either by preventing them altogether or protecting against them. These duties extend to events organised by you for your staff, even if they are held at an external venue. Now, if you fail to meet your health and safety obligations, the health and safety executive could take enforcement action against you. And the health and safety executive has taken action against employers in the past for exposing their staff to health and safety dangers at a work party. So it isn't just a theoretical risk. Now, while staff cannot sue you directly for breaches of health and safety law which adversely affect them, you are subject to other obligations which could give rise to a claim against you. First, it's an implied term of the employment contract that you will take reasonable care of the health and safety of staff. If you fail to do so, an employee could sue you for breach of contract, or if the breach was really serious, even constructively dismiss themselves and sue you for constructive, wrongful, and unfair dismissal. Second, you also have a common law duty of care, not to cause harm to your employees. If you breach that duty and an employee is injured as a result, then they may be able to sue you for negligence in the civil courts. So thinking about the party then, what exactly should you be doing to take care of the health and safety of staff? Well, you should risk assess the venue itself. This involves looking at usual things like fire hazards and escape routes, gas and electrical safety, trip hazards, presence of asbestos, and so on. But your risk assessment should also consider the main risks arising by the nature of the event. For example, the fact that there may be very loud music and the fact that people will be drinking a lot of alcohol, and probably a lot more than usual. If you don't provide food and you offer a free bar until the early hours of the morning, it raises the risk of people drinking to excess and perhaps making themselves ill or doing something reckless and hurting themselves or others. Another issue to consider is that staff will be traveling home late from an unusual location and most likely after having drank a lot of alcohol. Although you're not generally responsible for the safety of staff during their commute, it is sensible to offer some form of transport to help them get home safely and avoid them taking risks such as drink driving or traveling home alone on public transport when drunk. But is that enough? Should you limit alcohol? Should you have sober guardians policing the event? Should you anticipate every possible risk that might arise when people have been drinking too much? In other words, how far should you go? Well, the case of Shelbourne and Cancer Research UK Limited provides some helpful guidance for employers. In this case, Cancer Research held a Christmas party at which alcohol was served. Mrs. Shelbourne worked for Cancer Research, and Mr. Bielik was a visiting scientist, but he was not employed by Cancer Research. At the party, Mr. Bielik attempted to pick Mrs. Shelbourne up on the dance floor, but he lost his balance, dropped her, and she sustained a serious back injury. She then sued Cancer Research for negligence and argued that an employer who is organising a party at which alcohol is served must comply with the list of requirements that she put forward. The High Court concluded that a reasonable person would not regard Mrs. Shelbourne's suggested list of requirements as appropriate to impose upon the organisers of any Christmas party. Whilst it said that employers do owe a duty of care to staff, the extent of that duty is context dependent, even in social settings where alcohol is served. In particular, Mrs. Shelbourne's suggestion that a social gathering of this kind could not be adequately monitored by those who were involved in the gathering, but only by specially trained people, was to set the standard of care unreasonably high. Now, this case is helpful for employers as it shows there are boundaries to what is expected from you. However, Mrs. Shelbourne didn't stop there. She ran an alternative argument whereby she said that even if Cancer Research wasn't negligent itself, Mr. Bielik was, and Cancer Research was responsible or vicariously liable for that. And now Sam is going to think about the question of vicarious liability.
Thanks, James. So it is possible for you as an employer to be responsible for the acts and omissions of your staff, and this responsibility is known as vicarious liability. And this covers liability for breaches of legal obligations by employees, and they typically arise where an employee is negligent and injures another person. You also could be liable for the discriminatory actions of employees, and there are special rules in the Equality Act 2010 governing how this works. And I will look at each of these in turn. So for an employer to be vicariously liable for their employees' actions, there must be a close enough connection between the field of activities entrusted to the employer and their wrongful conduct, which means that it is just and reasonable to hold the employer legally responsible. And when it comes to social events, the courts have held that actions taking place at those events may pass this test, but it will be a fact-specific issue. So returning to the Shelbourne case James mentioned a moment ago, Mrs. Shelbourne also sought to argue that cancer research was vicariously liable for her back injury. She said that Mr. Bailick's field of activities on the evening of the party was to interact with fellow partygoers in alcohol-infused revelry, leading to the setting aside of the usual boundaries of social interaction. She said this was authorised by cancer research for its own benefit, since it stood to gain from the increase to staff morale. However, as you may be glad to hear, the High Court rejected this framing of the Christmas party. It said it was not one that the archetypal reasonable person would recognise as representing reality. And as a general matter, it overstates the position of the employer and conversely seriously understates the motivation and autonomy of those attending the party. The court held that Mr. Bailick's field of activities was in fact his research work at Cancer Research, and this was not sufficiently connected with what had happened at the party. Now, there are, however, cases that have been decided the other way, and an employer has been found vicariously liable. And to illustrate this, James will discuss the Bellman case later on. The takeaway point is that there are no hard and fast rules, and it will be necessary to look at what has happened and to apply the test. Now, given that employers could be responsible for the negligent actions of employees, the best way to mitigate this risk is to remind staff in advance of the standards of behaviour expected from them before the event. And I'll come back to this in just a minute. When it comes to discrimination and harassment, vicarious liability works slightly differently in that it is expressly addressed within the Equality Act 2010, and there is also a defence available to you as employers. The Act provides that anything done by an employee in the course of employment is treated as having also been done by the employer, whether the employee's acts were done with the employer's knowledge or approval. So what does in the course of employment mean here? Well, clearly it covers acts in the workplace, but it may well also extend to acts which are performed outside the employer's premises. For example, whilst employees are travelling, working remotely, or attending social functions. And this means that countless employers have found themselves liable for the acts of employees which have occurred at the pub after work, or indeed at Christmas parties. And just a couple of examples of these. In one case, the EAT held that an employer was vicariously liable for an act of sexual harassment that was committed in a pub outside working hours. The EAT said that social events arising immediately after work or during an organised party were within the course of employment and could be distinguished from, say, a chance meeting between employees in a supermarket. In another case, the EAT held that sexual harassment that had occurred during a work Christmas party and continued during a car journey home was part of a continuing course of harassment, and that was within the course of employment. They said there was no justification for distinguishing between the harassment at the party and the harassment in the car. So an employer can be vicariously liable for discrimination or harassment committed by an employee at a Christmas party. And this may obviously be of concern to you as employers because free-flowing alcohol impairs judgment and disinhibits people, meaning they may well say and do things that they would not ordinarily do. And so the risk of harassment, and particularly sexual harassment, is suddenly elevated. Now, when it comes to vicarious liability for discrimination and harassment, the good news is that there is a defence available to employers who can show they took all reasonable steps to prevent the employee from doing the discriminatory or harassing acts. And the reasonable steps that would usually be required from employers include the following. So firstly, having well-drafted equal opportunities and anti-harassment and bullying policies in place, and ensuring that all workers are made aware of those policies and understand them, providing equality training to staff with additional training for managers. And the case of LA UK Limited and Galen made some really interesting observation on when training will be and won't be good enough. And these are particularly important for you as employers to be aware of. The EAT said the length and the depth of the training is important. So brief and superficial training is unlikely to have a substantial effect in preventing harassment, whereas in contrast, thoughtful and forcefully presented training is more likely to be effective and will also last longer. Training will also need to be refreshed from time to time. So if it becomes clear that harassment is still occurring and or that staff didn't understand the training, you will then be on notice of the need to take further steps, such as to improve and refresh the training. Other general steps to take include dealing with complaints quickly and effectively and taking appropriate disciplinary action where needed. And whilst this isn't a preventative step per se, it demonstrates that you apply your equal opportunity and anti-harassment policies seriously and are not merely paying lip service to them. Also, if you have knowledge of or suspect that a particular employee might commit inappropriate acts towards another employee, then this might trigger the need for some specific steps to be taken. So in one case, an employee confided in her line manager about some concerns she had about another employee, but she did so confidentially and as a friend. Now, although the circumstances in which she had disclosed this information were relevant, there were still steps that the employer should have taken. For example, to warn the perpetrator about their behaviour, to subject them to closer supervision, and to tell other managers to be extra vigilant. Bringing all of this together then, what are the practical steps that you can take which might help protect your business from the risk of vicarious liability? Well, firstly, remind staff of their obligations. And whilst not wanting to be a killjoy, we suggest employers circulate a note before the party, reminding staff that it's a work event and they are required to conduct themselves in a mature and responsible manner, to consume alcohol in moderation, to take care of their own health and safety and that of others, that violence, aggressive, reckless, or other negligent behaviour will not be tolerated, and that acts of discrimination or harassment will not be tolerated. You could also cross-refer to other relevant policies, such as your health and safety policy, equal opportunities and anti-harassment policies, after making sure they are fit for purpose, of course. You may want to even go further and outline that inappropriate behaviour has a range of potentially serious consequences, including disciplinary action leading to dismissal, costly actions against the company, and potentially against them personally too. If you operate in a regulated sector, then you may need to report certain behaviours to the regulator. For example, violent, discriminatory, or harassing behaviour may mean that an FCA-regulated employee has breached rules on integrity and may not be judged as fit and proper to do that role, meaning they may be unable to continue with their role. And if the behaviour is criminal, it may also need to be reported to the police. Now, you may feel that that is too heavy-handed, but I think if you've experienced these issues in the past at staff parties, then going this far in your communication to employees is not necessarily a bad idea. Other things to think about, to underline to managers their special responsibilities. For example, they should be setting an example in terms of behaviour, and they should intervene if they witness any inappropriate behaviour. And as I've said before, where you are aware of a particular risk of discrimination or harassment, then they may need to be extra vigilant around a particular member of staff. Also think about whether your training needs a refresh. So for example, if you ran equality and harassment training 2 years ago, and you've had a complaint of harassment since then, this would be a sign that it should be refreshed. And the risk is that if you don't do that and you receive a complaint of harassment after the Christmas party, this may hinder your ability to rely upon the training as part of your reasonable steps defence. You should also consider deterring staff from after parties, and it's advisable to do so. This includes expressly stating that the official function is the only function funded and approved by you, and any events afterwards are not sanctioned by you and discouraged for the safety of all employees. Now, this may not be a golden bullet, but it may be helpful in demonstrating that any after party should not properly be regarded as being in the course of employment. And finally, deal with complaints swiftly and effectively. And if despite all of your best efforts, things do go pear-shaped, make sure that complaints are properly investigated and also treated with the necessary degree of confidentiality and sensitivity. And James will deal with this point later on.
Thanks, Sam. So let's think about some specific problems that may arise at the party. Well, excessive alcohol. Drinking alcohol at a work Christmas party is not a problem in itself in the way that drinking alcohol during working hours might well be a problem. But problems may arise when alcohol is used excessively, leading people to act out of character. We've already seen that it can present a safety risk, but what other HR headaches can it cause? First, loose lips. By loose lips, we simply mean problematic comments made by employees after a few drinks. This could encompass sexual harassment if the comments are of a sexual nature, Employees need to understand that even well-intentioned comments, for example, a compliment about someone's attractiveness in their party dress, can be problematic. Harassment on other protected grounds, for example, joking to a Muslim colleague that he is a killjoy for staying sober, could amount to harassment on the grounds of religious belief. Breaches of confidentiality, if an employee discusses something they'd agreed not to talk about, or an outburst of swearing or aggressive language. All of these are examples of matters that may require formal disciplinary action to be taken, depending upon the circumstances. But loose lips can also potentially land employers in hot water. In one case, an employee claimed constructive dismissal after he said his employer failed to honour a promise of a pay rise which had been made to him at a Christmas party. In that case, the employment tribunal found that whilst some remarks were made along those lines, they did not constitute a binding contractual commitment, particularly in light of the setting in which they were made. The claim was dismissed, and that decision was upheld by the EAT and Court of Appeal. Now, whilst this is ultimately a good outcome in the end for the employer, this situation should never have happened, and I suspect the employer wasn't too happy about having to fight the claim all the way to the Court of Appeal. Managers should be reminded not to talk shop at the Christmas party, and they certainly shouldn't be discussing things like pay and benefits or other sensitive matters, such as performance, conduct, or health issues with their team members. However, it's not just words we need to watch out for. Things like being sick in the middle of the dance floor, stripping off in the photo booth, stealing traffic cones outside the venue, or falling asleep in the cloakroom can all occur. And how you deal with this will entirely depend on what the behaviour in question is. Is it reckless or dangerous? Is it disrespectful to others? Does it breach the terms of the individual's contract or a policy? If yes, disciplinary action may be called for. And overdoing it on the night may also lead to a hangover the next day. Now, if the employee is booked the next day off or has a non-working day, they can suffer their hangover in peace. However, if they're meant to be working and they phone in sick but give another reason for their sickness, possibly because they don't want to say they're hungover, this creates a problem. Pulling a sickie is a dishonesty offence and may justify dismissal. In one case, the EAT said that making up an illness or exaggerating its effects in order to take fraudulent sick leave amounts to dishonesty and a fundamental breach of the trust and confidence that is at the heart of the employer-employee relationship. Employers should therefore warn employees in advance of the party that unauthorised absence on the day following the party will be treated as a serious disciplinary matter, unless, of course, the employee submits a GP's letter or fit note confirming the sickness. Sam's now going to have a look at some more alcohol-related problems.
So with everyone dressed up in a good mood and with the usual workplace inhibitions long forgotten, it's no surprise that many a romance has started at the work Christmas party. So is this really a HR problem? Not necessarily, and it doesn't have to be. A budding romance between two consenting adults need not be a problem. And indeed, there are no specific employment laws prohibiting consensual relationships at work. And in fact, I think I'm pretty well placed to talk about this issue, as nearly 10 years and 2 kids later on, my own budding romance at a Christmas party ended up turning out rather well. But romantic relationships at work can sometimes present a variety of difficulties for employers, notably the risk of a conflict of interest if one party has managerial responsibility for the other. The more senior party could easily end up in a situation where his or her loyalties are divided between the company's best interests and those of their partner, for example, when conducting appraisals or pay reviews. Romances can also prompt complaints of bias and favouritism and can lead to decreased morale amongst other workers. They're also quite likely to generate office gossip and could lead to other unpleasant behaviours such as cold shouldering of one or both members of the couple. And there's also the risk of negative fallout if the relationship breaks down. For example, if one party tries to pressurise the other one into getting back together, this could give rise to claims of sexual harassment. So what can you do to mitigate these risks? Well, an outright ban on personal relationship at work is not very attractive and may even be unlawful, since it is likely to represent an unjustifiable interference with an employee's right to a private and family life. So a better approach would be to attempt to regulate the conduct of personal relationships at work by putting in place a relationships at work policy. Such a policy should set out the behavioural standards expected from those entering into a personal relationship at work, however brief that may be. Crucially, a policy should include a provision requiring a party who enters into a personal relationship with either their subordinate or their manager or any other member of staff where there is still a potential conflict of interest to disclose the fact to HR as soon as possible. The policy should also address how the company may respond to such a disclosure, for example, by moving one of the parties to a different role or putting in place other safeguards.
So let's now think about unwanted sexual advances. Unwanted conduct of a sexual nature which has the purpose or effect of violating a person's dignity or creating a hostile, intimidating, degrading, or offensive environment will amount to unlawful sexual harassment for which you may be vicariously liable. Sexual harassment covers a wide range of unwanted behaviours that might arise in the context of a Christmas party, including banter, jokes, gestures, comments, and physical touching of a sexual nature. A few important points to remember when it comes to sexual harassment are individuals who go along with the behaviour. A worker may actively go along with or even encourage certain behaviours for some time, for example, banter, but then reach a tipping point where the behaviour becomes unacceptable and constitutes sexual harassment. Also, one-off incidents. A one-off incident can be unwanted conduct, which constitutes sexual harassment. And behaviour can be unwanted, even if not directed at the complainant. For example, a worker is entitled to complain that they find behaviour offensive, even when it's not directed towards them, or where there was no intention that they would see or hear it. Sexual harassment also arises where a person is subjected to less favourable treatment because they have either rejected or submitted to unwanted conduct of a sexual nature. An example would be if a manager propositioned a junior member of his team at the party. She rejects his advances, he accepts that, but then she is later turned down for a promotion which she believes she would have got if she had not rejected him. If proven, this would be sexual harassment. Now, by taking all of the reasonable steps we talked about earlier, hope is that you will deter this behaviour altogether. However, if it does occur, it must be investigated and disciplinary action taken where needed. Another really important issue to be mindful of is whether a budding romance can be said to be genuinely consensual. Typically, these situations arise where there is a power imbalance between the parties, with the more junior colleague feeling unable to reject the more senior colleague's advances. This is likely to be exacerbated by the consumption of too much alcohol, which impairs judgment and means it may not be possible to give informed consent. In one case which hit the headlines a few years ago, a partner at a Magic Circle firm went before the solicitor's disciplinary tribunal, following allegations that he had sexually harassed a junior colleague who had not genuinely consented to what took place between them. Now, whilst their accounts differed as to what they said happened, the SDT said that the partner was guilty of professional misconduct, finding that he was the junior supervising partner, he knew or ought to have known that the junior was heavily intoxicated and her decision-making was impaired. He knew or ought to have known that although she had agreed to him coming into her house to use the bathroom, she hadn't invited him to have sex with her. And in all the circumstances, he knew or ought to have known that his conduct was an abuse of his seniority, authority, and/or inappropriate. And that was really the critical point in that case. Now, the High Court eventually overturned the SDT's decision, but obviously not before the partner had moved on from his job and undoubtedly suffered reputational damage. So what can you do to prevent this situation arising? Again, it's going to be a case of educating employees in advance, warning managers that they're in a position of power which they should not abuse, limiting alcohol consumption, and providing safe transport home. If you observe situations which ring alarm bells on the night, it may be necessary to intervene. And this is perhaps one reason why having some sober guardians in place is a sensible idea.
It's possible that some employees will take things beyond the consumption of alcohol and move on to illegal drugs. And it's natural to assume that this is straightforward gross misconduct, one strike and you are out. However, we would sound a note of caution here. It is worth remembering that if an employee is drug dependent, as opposed to using drugs on a purely recreational basis, then this may necessitate a different approach, as the drug dependency may be a symptom of a disability, such as depression. If so, the employee would have protections under the Equality Act 2010. Now, that does not necessarily mean that you couldn't dismiss for drug taking in those circumstances, but it would raise the stakes and as such require you to do things slightly differently. for example, obtaining medical evidence and understanding the prospects of rehabilitation. Therefore, if an employee were to raise dependency in their defence, it would be sensible to pause and to take advice before moving to dismiss. In a Christmas party situation, however, you are more likely to face the scenario of employees taking drugs recreationally, and here you may well be justified in taking a less tolerant approach, particularly where you have a disciplinary rule which stipulates that drug use at work is prohibited and will be treated as a gross misconduct offence. If you have a clear rule, this will put you at an advantage when it comes to justifying any summary dismissal. You will be able to say that the rule operated as the warning to employees of the consequences of taking drugs, even just once, namely that they may be dismissed. But the rules need to be clear and the employees need to know about it. So you might want to check your disciplinary rules and ensure that this is captured. And if not, we suggest you update them and recirculate to employees. And whilst a rule like this will help you to achieve a fair misconduct dismissal, don't forget that you will still need to show that you've acted reasonably in all of the circumstances. This therefore means that you would still need to conduct a proper investigation and follow a fair process prior to dismissal, including holding a hearing and offering an appeal. You would also need to consider the following when reaching your overall decision: that any defence offered by the employee, whether you are taking a consistent approach with other issues that have arisen, the employee's service record, and although this won't be decisive, it is a factor to take into account. For example, in one case, an employee was dismissed for possession of cannabis at work, even though he had 21 years of service and a clean disciplinary record. And it was held by the EAT that it was plainly within the range of reasonable responses available to the employer in this situation to dismiss. You also need to take into account any mitigating circumstances. For example, in one case, an employee claimed that he had smoked cannabis at work because of matrimonial difficulties. And the tribunal said that a reasonable employer would not have dismissed, but would have given him an ultimatum and waited to see if he would seek help and or change his ways. Therefore, if an employee says that the drug taking was a direct result of stress, we'd advise investigating that point further and consider the provision of additional support before making a decision. And in our view, it's always better to pause and make the right decision now rather than rush to make a decision and have to deal with any fallout or any tribunal claims thereafter.
And a bit like drugs at work, fighting at work is generally regarded as gross misconduct, justifying dismissal without prior warning. This can include off-duty fighting at work events and even after such events. For example, in one case, an employee had an argument with a colleague straight after the end of the work Christmas party and then punched another colleague who was trying to defuse the situation. He was dismissed and he argued that as the incident occurred outside work, it could not have been misconduct justifying dismissal. However, the tribunal found that the events after the Christmas party had a close enough connection to the employment relationship to mean dismissal was reasonable. Whilst almost all employers will have disciplinary rules which state that fighting will be treated as a gross misconduct offence, sometimes there may also be factors which mean it's not appropriate to dismiss. For example, if an employee involved in the fight was not blameworthy, for example, they were provoked or acted in self-defence, this really underlines the importance of conducting a thorough investigation to get to the bottom of things. Other general factors which may also mean that dismissal is not reasonable in the circumstances include the employee's length of service, their disciplinary record, consistency of treatment with other employees in similar situations, and whether the employee is remorseful. However, when it comes to violence and fighting, it's not just the dismissal of the perpetrator that land on HR's desk. If the other party to the fight is injured, the company could be sued on the basis that it is vicariously liable for the actions of the perpetrator. Now, this is what happened in the case we flagged a little earlier on, Bellman and Northampton Recruitment Limited. It concerned the serious assault of an employee, Mr. Bellman, the managing director of the company, Mr. Major, at an after party following the official work Christmas party. Now, the after party took place at a different venue to the Christmas party. It wasn't compulsory to attend, and it was attended by some employees and some non-employees. During a work-related argument, Mr. Major punched Mr. Bellman twice, causing Mr. Bellman to fall over, hit his head, and sustain severe brain damage. Mr. Bellman sued the company, alleging that it was vicariously liable for Mr. Major's conduct. Now, the Court of Appeal upheld the claim, concluding that there was a sufficient connection between Mr. Major's field of activities and the assault in question, even though the Christmas party and after party were separate events. Why was this the case? Well, the court said that despite the time and place at which the assault occurred, Mr. Major's position of seniority persisted and was a significant factor. He was in a dominant position and had a supervisory role, which enabled him to assert his authority over the staff who were present and to reassert that authority when he thought it necessary. It was also relevant that immediately prior to the assault, Mr. Major chose to wear his metaphorical managing director's hat and to deliver a lecture to his subordinates. However, the Court of Appeal in that case did sound a note of caution, stating that the facts were really quite unusual and that vicarious liability will not always arise where there's an argument about work matters which leads to an assault. As we said earlier on, it's really dependent on the facts.
And finally, another common problem we see at or after Christmas parties is gossiping about the juicy events that took place at the Christmas party. And gossip is a fact of life, but it can be problematic for you as employers, since it could damage team morale or even amount to bullying. And depending on how bad it is, it could lead to the employee resigning and claiming constructive dismissal. Gossip could also amount to discrimination or victimization depending on the circumstances. And this is highlighted in the case of Nixon and Roscoe's solicitors. In this case, Ms. Nixon was in a relationship with a colleague. At the Christmas party, she was seen kissing another colleague and going up to a hotel room with him. This led to gossip amongst staff when, a few weeks later, the employee announced that she was pregnant. The employee raised a grievance, which the employer did not deal with, and she ended up bringing a claim which was upheld. And the EAT said that the gossip about the paternity of her child was clearly harassment on the grounds of her pregnancy, even though she had acted in a manner which was bound to provoke the gossip. Ms. Nixon also succeeded in her constructive unfair dismissal claim. And don't forget that online activity can also cause headaches, whether it is posting photos of someone without their consent or gossiping about what they got up to at the party. Again, this is highlighted in a case of Teggett and Teletech. Mr. Teggett posted obscene comments about the promiscuity of a female colleague on his Facebook page. It came to the employer's attention, and Mr. Teggett was dismissed for harassing a colleague and also bringing the company into disrepute. Mr. Teggett claimed unfair dismissal, but that was rejected. The tribunal said it was reasonable for the company to conclude that Mr. Teggett had harassed a colleague and that this was serious enough to justify dismissal in the circumstances. But as a further note of warning, whilst his colleague did not actually bring a claim against the company, she could have potentially said they were vicariously liable for Mr. Teggett's harassment of her. So if you become aware of office or online gossip, be sure to nip it in the bud at the outset, and if necessary, take disciplinary action.
Despite your best efforts, problems may still arise. And if they do, your actions in responding to the complaint or the misconduct are really important. So before we wrap up today, let's pause to think about the steps that might make the HR hangover a little bit less painful. So dealing with complaints, you should take all complaints seriously and deal with them promptly. Failure to do so could compound the problem and expose you to claims. So don't forget to conduct your process in line with your own grievance procedure and the ACOS Code of Practice. You should also remember that raising an internal complaint is difficult for an employee at the best of times. And that's especially the case where the employee has received upsetting or even traumatic treatment, perhaps at the hands of a senior colleague. There are things you can and should do to support the victim and avoid creating any further stress. For example, don't give a deadline by which a complaint of sexual harassment must be made. That's because workers who've been sexually harassed may not raise the complaint immediately due to the trauma they've experienced and/or a fear of victimization. You should also make sure that the process is confidential to try to avoid gossip and further victimization. And be flexible in your approach. For example, a woman who's been sexually harassed may feel more comfortable talking to a female investigator. She may also not want to bring a colleague with her as a companion to the hearing, as she might not want them to hear what's happened. So consider allowing her to bring a friend or family member instead. Make sure the process is completed as quickly as is reasonably possible, as an unduly lengthy process can also aggravate feelings of stress and worrying. And think about any assistance you can offer the worker, for example, counselling or an employee assistance helpline. And if that employee takes time off sick with stress or depression, pressurize them to return, assuming it's appropriately certified, of course. Work with them to try to get them back to work, making any reasonable adjustments to their work pattern or arrangements that would help. The victim may also be concerned about the prospect of retaliation from the alleged perpetrator, and perhaps from other colleagues, for having raised an internal complaint of harassment. Remember that if a worker is victimized, this gives rise to a further legal claim. Therefore, it's in your best interest to make sure this doesn't happen. The perpetrator and other colleagues who know about the matter need to be reminded of their duty not to victimize. You should monitor the situation, being mindful that victimization can take many forms, from outright adverse treatment to things like cold shouldering and gossiping, as we mentioned earlier. Also, some complaints may also concern behavior that amounts to a criminal offense. For example, sexual touching will quite likely amount to sexual assault under the Sexual Offences Act 2003, or physical violence will amount to a common assault, or even ABH or GBH. If an individual makes a complaint of behavior that may amount to a criminal offence, you should raise with them the possibility of reporting the matter to the police and provide them with the necessary support that they need to do so. But what if they choose not to do so? Well, you should give the complainant's wishes a significant amount of weight. If they don't wish to report the matter to the police, then in most cases you should respect that wish. In most cases, the police will be unlikely to be able to take any action without the complainant's cooperation. However, in certain situations, an incident should be reported to the police, regardless of the complainant's wishes. In that instance, you'll need to weigh up the risk of reporting the matter to the police, contrary to the claimant's wishes, against any risk to the safety of the complainant, their colleagues, and third parties if the matter isn't reported to the police.
So where a complaint is upheld, or even where there has been no complaint, but you are aware of misconduct, then you may need to institute disciplinary proceedings against the wrongdoer. And if you fail to discipline a perpetrator of harassment, this could put you in breach of any relevant regulatory expectations for dealing with such matters. Further, if you protect a perpetrator, this could also lead to an award of aggravated damages in any claim brought by the victim. And this is an additional award made where the respondent has behaved in a high-handed, malicious, insulting, or oppressive manner. And again, this process should be conducted promptly, fairly, and in accordance with your disciplinary policy and the ACAS Code of Practice. If you are a regulated employer, you will also need to consider whether and when to report the matter to your regulator. For example, firms must notify the FCA when formal disciplinary action for discrimination or harassment is taken against certain staff. And in certain circumstances, a report may need to be made before formal disciplinary action is taken. And in cases of serious misconduct, there may also be parallel criminal processes ongoing. And if so, you should discuss your disciplinary process with the police. Don't just assume that you can't take action to investigate the matter until the police inquiries or any subsequent prosecution have concluded. You should check with the police that you can carry out your own investigation without prejudicing any criminal process. And if it is safe to do so, then you should consider whether it would be reasonable in all the circumstances to continue with an investigation immediately rather than to await the outcome of the criminal process. If you do decide to proceed, you may need to take special steps in your procedure. For example, the accused may have to be interviewed under caution, and specialist criminal law advice will probably be needed in this case. Even if a criminal investigation does not result in a conviction, again, don't assume you can't take further action. This is because criminal offences have to be proved beyond reasonable doubt, meaning that there must be clear evidence supporting the allegation against the accused. An employer, on the other hand, need only have reasonable grounds to conclude that a disciplinary offence has been committed.
So that brings us to the end of today's webinar, and by some Christmas miracle, I think we've actually managed to do it in 45 minutes. So I'm surprised that we've achieved that. Fantastic. We hope you enjoyed the webinar, and we hope you picked up some useful tips to ensure that your party goes off with a swing. On the slide, you'll see our contact details. Please do feel free to get in touch with us in connection with anything we've discussed today.